देशपांडे सर आलेत का? जॉईन झाले? कायटे सर?
होत आहेत.
Very good morning to all. Am I audible to all?
Yes,
Okay.
sir. Yes.
Okay. A very good morning to all of the participants, my colleagues, and all my friends and student fraternity. Also, good morning to all the research scholars who also taken initiative to join for today's national webinar, which is organized by Department of Law, Government Institute of Forensic Science, Aurangabad, as a taken initiative as far as in the digital era is concerned to make sure about the more informative sessions on the intellectual property rights, in particular the domain of the patents are concerned. So today we have a very great resource person with us, Professor Dr. Padmavati, IIT Kharagpur. I am very welcome to you, ma'am. Very good morning to all of you, and very welcome to you on behalf of our Government Institute of Forensic Science, Aurangabad. Our director is also a precious present for today's national webinar.
Right, sir.
Gaude sir, please continue.
Continue करा.
मी कंटिन्यू करतो. Good morning to all of you. Today we have with us
Under his guidance, we have taken initiatives to.
Gaude sir, continue करा.
Today we have with us Dr. M.Padmavati madam from IIT Kharagpur, and she is going to talk about the patent and the patent process in India, whether that be the product patent or the process patents. So what are the formalities for the registering your patent? So I now request the director of our institute, Dr. S.M. Deshpande sir, to kindly talk about this webinar.
Thank you, Gaude sir. I welcome the speaker of the day, Dr. Padmavati madam from IIT Kharagpur. Personally, I know that the madam is the renowned person in the field of patent one. Also, I welcome all the participants of this webinar. Being a director, it's my responsibility to tell about my institute a bit. Government Institute of Forensic Science, Aurangabad, is one of the leading institutes of the country which imparts quality education and research in the field of forensic science. The institute was established in the year 2009, and it is governed and funded by the government of Maharashtra. The Forensic Institute of Science completed 11 years. In the journey of past 11 years, we are working in hand with our stakeholders to have a crime-free society. So far, we have trained more than 10,000 police personnel and helped them to solve more than 500 crime cases. We believe in academic excellence, which should be directed for the development of the society. Seeing our academic excellence and world-class curriculum, Government of Maharashtra recommended Government Institute of Forensic Science, Aurangabad, for the Center of Excellence in collaboration with CIC London under UKERI program in the year 2015. We know that we are now in the digital era, and transformation of the digitalization is going on, where we want a smart solution in every aspect of life. So, as concerned to today's webinar, the topic is chosen for the patent and filing of the patent process and all these things. I am sure that this deliberation will be helpful for academic communities and working professionals. I welcome you once again and congratulate the organizing committee and the head of department, law department, for organizing this kind of webinar with large participation. I wish this webinar a grand success. Thanks one and all. Gaude sir, continue kara.
Yes. Now I request Dr. Padmavati madam to kindly give a speech about the patent process in India.
First of all, very good morning. Thank you, Dr. Deshpande, for this wonderful introduction. It is indeed a pleasure. Thank you for the invitation. It's a pleasure to talk to you all, and I'm very happy to note the collaborations that you have as a Government Institute of Forensic Sciences, and I'm sure you're looking at a lot of technology development. Good morning, Dr. Bharati, the HOD of the Department of Law. Thank you for coordinating this. All the participants, welcome to this session. I will be in a matter of another hour to about 1.5 hours. Will take you through the process of what is the important aspect in relation to patenting and the procedure in India in relation to patent filing. I'll try to make it as illustrative as possible. So let me share my presentation with you all so that we can get started. I hope you can see the screen.
Yes, ma'am. Yes.
Okay. Yeah. Today I will be dealing with patenting aspects and the procedure for patent filing in India. Let me set the background of the presentation. So we'll deal with the importance of research and development and how that has a very critical role in relation to fostering inventions, and what is this invention process. So we need to understand that. Then there is an aspect of patent law which we need to know. That is, every invention has to clear the requirements as specified under patent law. So we'll understand the substantive aspects of the criteria as well as the procedural aspects of patent filing. So let me take you to the first part of the presentation, which sets the background of what are these things called inventions, why are we into it, and what is the value. So as most of you may be aware, that research and development involves the preliminary phase of what we call the gathering of information and experimentation to look for important products as well as processes. And often we are looking at the identification of new products and processes, and obviously both of them. The identification of new products and processes depends obviously on the technical area. So research in a concerted way may lead to these new or novel products and processes. Obviously, there is a time lag when we talk about research to the phase of identifying something which is a novel technology. The developmental phase is where we see the fine-tuning of the process or the product. Most often, people do come across what we say the proof of concept. So when you know that a novel product or a process actually has value, you have experimented with it, you have tested it, that is where we come to the concept of what we say prototype. So a prototype is basically a proof of concept. That is, something is workable. There is a product, if you have made certain components of it, and then you're coming close to achieving the first proof of concept in relation to that. Now, this is a very important stage because it is at this stage you're almost like created the blueprint of your product or a process which you would like to implement in future. There are two routes that are available to us at this stage. Either we go for a direct technology transfer, that is, the prototype that you have created has immediate market value, in which case you may want to really transfer your technology directly. The other route is to go for a patent filing, that is, go through the process of filing at the patent office, and then again you can go to the technology transfer. Why is it that we have these two routes? Because if one must remember that once the prototype is ready and all that is required is to put it into a production plan, and if the technology is needed by the market, it's best to transfer the technology. Then why is it that we are looking at patenting in that case? We look at patents because that provides some sort of a background protection to your technology. Remember that if you have the technology and you want to really bring it into the market, there will be many others who may be copying your technology. So protection of a technology is also a consideration when we come to the aspect of bringing it into the commercialization phase. Generally speaking, what can be done is at least you should go for an initial patent filing, which is at least file the provisional application, and then again you can go to the technology transfer route. So as we go through the presentation, I will be touching upon some of these aspects. So why technology transfer? Because that is where we are looking into bringing in innovative technologies into the market and implementation of those. Licensees will have an opportunity to actually take up your technology. Not only that, it also creates an investment opportunity for the production in a particular phase. It also provides opportunities for collaboration, that is further development of technologies. And so therefore, this is where we see the paradigm in so far as research and development and what are the different outcomes available. Sometimes inventors come to us with a prototype. And in fact, that is the critical stage at which we need to take a decision on whether we go for technology transfer directly or whether we go for a provisional filing and then move to the technology transfer. It is always desirable that at least the initial patent filing is done before we move with a licensing arrangement. So moving on with the particular process. So where is it that we come across the process of, the bringing down the invention into a clear-cut documentation? So that is what is called the invention disclosure process. And this is very important for all researchers to know. Gone are the days when we were involved in spontaneous research. Today, it's the time of induced research where we are driven into developing certain products and processes. So most institutions, industry, have this particular process called the invention disclosure process. What is this process? It is actually a formal process of disclosing the details of an invention into a specific writer. So why is this useful? It is useful because it helps you in documenting the invention details. And I would believe that the Government Institute of Forensic Sciences already has in place an invention disclosure process. And this becomes the first step towards looking at this document for either a direct technology transfer or go through the patent filing process itself. So what does this form actually have? It has the basic details of the inventors. It has the details in relation to the disclosure, in relation to the novel product or a process. And what is this novelty about? How is it novel in relation to the current state of the art? What is the commercial value of this particular invention in terms of the already available products or the segment that it can be useful? And of course, then there is an inventor signaturing process also. Remember that this is an important piece of evidence if you look at it from the point of view of patent filing. So once this document is ready at hand, then comes the next step of looking at, yes, this invention detail that has been disclosed, does it qualify for a patent filing under the patent law? And this is where we come to the aspect of understanding the criteria. So patent law prescribes that there are certain criteria in relation to filing as well as taking patents. So why are we discussing the need for understanding inventions? Remember that both the processes are very important. So the one is channelizing the invention process, and the next part is invention to the patent filing process. Both are adequately important. But then prior to the filing, channelizing the invention process is also very critical, because unless an organization is innovative enough, it will not be generating a lot of novel products and processes. So this is just a brief slide to indicate that today all of us need to have the mindset of innovation. Gone are the days when you are looking at innovation only in the lab, innovation on the fly, innovation through network collaborations. These have become very usual. So if you look at what are the general factors that are involved in the innovation pathway itself, I think first fundamental thing is encouraging creativity and a lot of openness in research, because remember that we may embark on a particular area, but we may end up finding out leads which are valuable for another area. So therefore, openness is very important. And always looking at the gaps in research. What is it that is not solved in the research? And what is it that we can do is important. Another important aspect is to undertake or inculcate the habit of patent search, because typically researchers tend to look at non-patent literature, which is the journal search, report search, but we deliberately do not do a patent search. But I think it is fundamental for every young researcher to inculcate the aspect of looking at patents, because patents are also literature. So patent literature is another literature where you will find a lot of innovative technologies. So inculcating that is useful. Many times we are also interested in collaborating with other partners, because that part of the invention can be worked out in a collaborative mode. Ultimately, I think the outcome should be in terms of what is the value addition that we are bringing into society and what impact it can have on society. So keeping these in mind is important for every researcher. And I deliberately wanted to put this slide because unless we are clear on this step and more innovating, the process of the inventions generation will be not that much. So that is something we need to keep in mind. Okay, now let me move on to the next, the second part of the presentation, which is the invention disclosure process to patenting. So what happens after you disclose the details of the invention into an invention disclosure? This is typically taken up either by the intellectual property cell, or you may actually approach an attorney who will be guiding you through the process of evaluating the disclosure for whether it meets the requirements under the patent law. Today, I think we have been able to close this gap. Earlier, researchers were not so very aware of patenting norms, but I can see, at least being the advisor to the IP cell IIT Kharagpur, more and more we see inventors coming up with the differences between the existing literature and their invention. And I think this gap is closing, and which is a good sign, because once the inventor is well aware whether or not the technology is novel, the first step is reached. So let me move into the next aspect of the presentation. So when we are looking at inventions, the first fundamental question that we need to ask is, does that invention represent a problem solution approach? So what is the solution that we are addressing in the prior art? And is it that this invention solves a particular solution or provides many other solutions? So this is where we call a very simplistic definition of what is called inventive step. So from an invention disclosure document, this is the first thing that we need to look at. So what is the problem that the inventor is addressing, for which the inventor is coming up with a solution, either in the form of a product or a process or both, or the inventor may be coming up with a system itself, which is implementable. So once you demarcate these both components, then we come to understanding whether that solution that we are talking about is novel. Is it so obvious? It has to not be obvious at all. So it is at that juncture we are actually putting it through the lens of patent law. So let me move to the next aspect of the presentation. So what is it from the point of view of the Patent Act 1970 we need to know? So if an invention, which is disclosed in an invention disclosure document, has to meet the requirements under patent law, it needs to meet the definitional requirements under the Patents Act. And what is invention? Invention is a new product or a process which involves an inventive step and is capable of industrial application. That means there are certain qualities prescribed for an invention for it to clear the law. One, it has to be new, it has to be novel. It has to be also having inventive step. Remember, we talked about the problem solution approach, and it has to have industrial application. Here, the connotation is capable of industrial application. That is, that there is a premise that industrial applicability is possible. So here the Act tells you very clearly, you don't need to show industrial application, but yes, general utility is a requirement. So let's move on to understand the requirements that need to be met. So simply put, every invention must meet the requirements of what we call, is it eligible under the law? I may be coming up with a great technology, but the technology is harmful to the public. And the technology is barred under the law, in which case it is not eligible. Then comes the aspect of novelty, non-obviousness, utility, and all of this has to be there in a concrete manner. That is, the examiner who is looking at your document must know where to look for novelty. And that is where there are also norms in relation to what you need to write in the specification, which is called disclosure norms. So let us examine one by one each of these particular aspects. So let me take you to the aspect of patent eligibility. That is subject matter that is open for patenting under the Indian Patent Act. So when we say subject matter, the Indian Patent Act says what are not inventions under the purview of Section 3. If you look at Section 3A to up to 3P is where you find all the aspects of what are the subject matter, that is, what are the inventions that are not allowed under the purview of the Patents Act. To give you a few instances, for instance, method of agriculture or horticulture is not patentable, but a tool which is involved in a method of agriculture may be patentable. So one must understand, are these restrictions complete or are these restrictions where you can actually look at the patenting forward in relation to some of these. Medical method treatments are not allowed, whether it is for animals or humans, but tools that are involved for, let us say, surgical tools, those are patentable. Plants and animals as such are not patentable. So their parts are also not patentable because it is against public order. It is living beings are not subject matter of patent. Fair enough, because patent is a negative right. What does that mean? If I get a patent certificate, I can bar all others in this territory to practice that specific invention. So these patent rights are therefore very strong rights. Similarly, there are many other aspects which we need to keep in mind so far as the subject matter restrictions are imposed under the Indian Patent Act. Something which is a mere discovery is not patentable. Something which is a new form of an existing substance already available, not patentable. So there are several of these aspects which we need to keep in mind, because yes, the technology may be very novel, but that novel technology is coming under the restriction in relation to subject matter. So therefore, we need to know what is eligible under the law, what is not eligible under the law, so far as patenting is concerned. Now, let me move to the next aspect. So when we know that, yes, eligibility requirements are taken care of, we come to the other aspect of the criteria. So what are the criteria? The criteria are novelty, non-obviousness, and every invention generally must have some utility. That is, it is capable of industrial application. So this is where we are looking at the patentability criteria. So when we say an invention is novel, novel against what? What is known prior to it? So suppose you, today, if you are going for a filing, that is the assumed date of filing. Prior to the date of filing, all that is called the prior art. That is all that is there prior to the invention. Obviously, a whole body of literature is available. What is in public knowledge, all of that comes into the prior art. We need to know that every invention must be new and it also should not be obvious. So if I'm changing a cap of let us say a pen from blue color to red color, yes, it is novel. There is a change in color. But don't you think it is very obvious? It is obvious that a color change is possible. So therefore, every novelty in relation to a particular product and process must also meet the additional criteria of that it should not be obvious under the law. So we'll look at what are the requirements specified under the law in relation to this concept called novelty on one hand and the non-obviousness on the other hand. Both the cases we are looking at prior art, but the application is different. We'll look through that as we move on. So what are the different prior arts that can be possible in relation to when we are actually comparing the invention with respect to what is already known? So simply put, if you see as this particular illustration, if an invention is already in public use, then you don't deserve a monopoly of 20 years on a particular patent because it is already there. It is no longer novel. Similarly, it may be published in a patent application, in a patent that is already there. It may be there as a part of a journal publication, a report, in which case your invention is not novel. Then there are certain meeting reports which are already published, survey reports are published, clinical trial information in case where it is not actually coded as sample, oral disclosures in the case of traditional knowledge, because traditional knowledge, not all of it is documented. So to protect traditional knowledge and not allow it to be patented, therefore you have oral disclosure in the case of TK is also relevant prior art. Prosecution history in relation to patents, library record, thesis, master's thesis, PhD thesis, all of these are also important. And patent applications which are abandoned in the later part of the patenting phase, available as publications, also are prior. Today, a whole lot of the internet has so much of information. So please remember, if you have an invention, avoid writing on a blog, avoid writing on Facebook, we avoid writing on any of those social media, because we may be very naive and ending up disclosing details of the invention. Remember, if it is already disclosed and you yourself have disclosed it, then it will amount to what is called self-anticipation, because your technology is no longer novel because you have yourself revealed the technology. It is existing prior to your filing. So there are certain important safeguards that we need to follow in order to make sure that your invention continues to be novel at the date of filing. So one is screening the details of the prior art are important, because someone else may have done it. You are thinking that your invention is novel, but it may not be the case. So keeping this in mind is very important. And of course, if you look at the law, it is prescribed under specific sections from 29 to up to 32 under the Patent Act. So simply put, we say an invention is anticipated. So if you look at what is the relationship between novelty and anticipation, I would say in a simple equation form that novelty is inversely proportional to anticipation. Okay, so the greater the anticipatory value of the prior art, lower the novelty. So that is where we need to look at the relationship. So whatever I told you about the prior art relations is what is there as an illustration here. Prior publications, prior claims in complete specification, display with certain exceptions, because sometimes in order to attract a commercial value or as a necessary requirement, you may actually put your product in the exhibition. But then there are safeguards available, because then you can write to the patent office that this is what you will be processing further. And so you can have that communication put up. In which case, even if you're going for this exhibition, it will not amount to self-anticipation. So prior communication to government, yes, there are exceptions to this as well. And of course, public knowledge and public working. So these are the relevant sections of the Indian Patent Act, which are need to be looked at from the point of view of looking at the requirements. So section 13 actually identifies the aspect of what is it that the examiner considers whenever we are looking at the aspect of the analysis of anticipation. And so this is what we were discussing so far. So I'm just skipping through this particular slides. 29 is by anticipation by previous publication, and so on. Anticipation by previous communication to government, by public display. All of these are the necessary framework that is given in order to come up with the analysis in relation to anticipation. Now, assuming that all of this is cleared, then yes, the examiner may clear you for the novelty in relation to an invention. Okay, so if you really want to understand, what is novelty in practical terms, remember, novelty is identity. That is, if you look at the prior art and if you look at your invention and there's a complete identical match, that is a mirror image, then yes, your invention is no longer novel. So if you see this, I've just shown you as an illustration. So if it completely matches the prior art, then yes, your invention is not novel any longer. So how do we do this? For instance, let's say you come up with a document to me, an invention disclosure, and I am looking at the prior art. And let us say I have got a prior art where A, B, and C are there. And let us say A only has a part of your invention, B has the other part of the invention. Does it mean novelty is met? No, novelty is not met. Why? Because it is not there as a mirror image, right? Between, if you look at A and B, when will it be a mirror image? In case a document A completely discloses the details of your invention, yes, that prior art A and your invention are completely matching, in which case identity is met. Therefore, the analysis of novelty is always 1-to-1. That is your invention vis-a-vis the prior art. So there is a requirement of a single prior art where you can look at the identity. And that prior art may be a prior publication. That prior art may be a single use, public use. That prior art may be an oral TK. So this is where we need to look at the analysis of novelty. Okay, once we clear the novelty part, then comes the aspect of, yes, your invention is novel, but is it clearly envisageable? Is it something that, well, your technology is novel, but in the current times, if I take it to a person who has experience in the area, he may say, yes, your technology is novel, but it is actually quite obvious. In which case we come to the next step of the aspect of determining non-obviousness. Okay, before that, novelty determination is done in different ways by the interpretation of law. One is the identity requirement. The other is what we call enabling disclosure. That is, the disclosure also tells you that this novelty can be reached by doing certain things. So simply put, it is that. And sometimes the document, when you read it, you get an idea that, well, there is a component called X, which inevitably has to be there. So that is what is called inherent anticipation, where the component X may not be mentioned explicitly in the document, but it gives you a certain substantial way of looking at that X necessarily has to exist. If X necessarily exists, then yes, though X is not named in the document, inherent anticipation will lie. So there are, of course, a lot of case law in relation to inherent anticipation, but when we discuss in law novelty standards, this is where we come across these particular terms. I'm not going into detail. We can maybe post it for the discussion during the question and answers. Okay, let me move to the next step. So an invention which is novel has to clear the additional step of what we call inventive step. Again, if you go back to the aspects of patent law, the definition of inventive step is defined under section 2(1)(JA) of the Patent Act. What does inventive step mean? If you see the ones which are in the colored part here of the slide, feature of an invention that involves technical advance. That is, what is it that you have done? What contrivance have you brought in relation to the invention that describes an advance over the existing art? If all I have done is repeated the prior art, then that means there is no inventive step. So inventive step is a technical advance over the existing knowledge. Now, the Indian Patent Act also gives you an option. That is, either it is a technical advance or has economic significance, or both. So this is where we would believe that the Indian Patent Act has taken into consideration that there are inventions which may not be technically advanced, but have value so far as an impact on society. Remember, we discussed about it in the initial slides. That is, this is an invention which has great economic significance so far as the use in the public is concerned, then yes, this will go through the aspect of inventive step. And both of these have an additional what you call subjective criteria. So these are the objective criteria, that an invention must represent a technical advance or economic significance. Now, what is the subjective criteria? This part of it has to be assessed by whom? It has to be assessed by a person who is skilled in the art. And that person who is skilled in the art, to him or her, it should not look obvious. So inventive step has two determinations. One is the objective criteria. The second part is the subjective criteria. So who is this person skilled in the art for us? It is the examiner. So to an examiner, when the invention details are presented, the examiner should get a feeling that, well, yes, well, the prior art doesn't have this. Yeah, there is a surprising value. Certainly it is an advance. Or the examiner must think, yes, There is a technology which is available, but very interestingly, they have reduced one step and it is economically significant. In a low cost way, you have recovered something, or maybe you have done an invention which is biodegradable in nature, in which case it has value to society. So these are the aspects of inventive step. As we move on, we look into the further consideration. So this is what I explained to you. The primary considerations are that technical advance, all of that. Secondary considerations is a typical concept which is under the US law. It has come up with the case law where commercial success requirements, all these are being looked at. Whereas in the case of the Indian Patent Act, it is coded. It is there as a part of the statute where we read economic significance as a part of it. Okay, let me move on. These are again available to you in terms of how do you address the commercial success argument. So these are the questions you will be posing to the inventor. Suppose an inventor comes to me with a documentation. The question that I ask when I know that the invention is not significantly a technically advanced one, then we look at, is it that there was a problem in the prior art and there were no solutions put forward? What kind of deviations the inventor has brought in, and how the patentee's development is actually relevant so far as the impact in that particular area is concerned. So these are some of the questions we ask when inventors come to us. Okay, so we discussed about the aspect of novelty when we came to a similar kind of a illustration. There, if you realized, we talked about identity. We didn't have so many prior arts. Now, suppose, let us say, you have gone through the process of novelty. The next question that comes to the examiner's mind is, fair enough, it is novel, the invention is novel, but is it that, it is obvious? So when do we come to this obviousness requirement being there, so far as the Patent Act is concerned? So whenever you combine multiple prior arts and still you're able to reach the invention, then what does it mean? Technology that you have developed is novel, but current state of the art says that, well, you have done nothing significant. If you have done nothing significant, do you deserve a monopoly of 20 years? So the question that comes is that if I combine multiple prior arts, that is, let us say, for simplistic reasons, an invention has 4 features. And these 4 features are distributed in these 3 relevant prior arts. Prior art 1, prior art 2, and prior art 2. So in a composed manner, you're still able to reach the invention, or you're mosaicing it to reach the invention, in which case obviousness is met. And so if you look at it, the illustration here, so this is where you're seeing the overlap, in which case the examiner will say, well, novelty is there, but your invention is still obvious in light of the prior art, and in which case that will be coming up as the response from the examiner in your first examination report. So keeping this in mind is important, because this is the next criteria. Of course, there is the third aspect of the criteria, which is utility. Every invention must qualify what we call general utility. Now, how do we say, if from an invention disclosure document, that an invention has general utility? That means the invention should be relevant to a particular industry where a production process can be set up. So generally targeting it to a particular area of development is an important requirement. Of course, if you look at, this is one interesting aspect of patent law, you see, where if you look at other laws, there are no such elaborate guidelines so far as the examination of applications are concerned. So suppose I have a mechanical invention, there are certain prescriptions for a document to be submitted in relation to a mechanical invention, okay, where we look at the drawing. So the drawing itself gives you an idea that, well, this is relevant to that particular, either a machinery, so that relevant industry. Now, if you come to biotechnology and pharmaceutical area, these are what are called unpredictable arts compared to mechanical, electronic, which are called predictable arts, because you can envisage the invention in those areas. So generally in the area of biotechnology and pharmaceutical area, it must be specific utility. That is, you're targeting that the product or a process to a purpose, a specific purpose, because general purpose doesn't have value so far as the biotechnology and the pharmaceutical industry is concerned. And so therefore, there are standards for utility also. If you go to the revised USPTO guidelines on utility, they have prescribed specific utility guidelines where an invention can have one general utility, specific utility, well-established utility, and many other norms like that. Substantial utility and credible utility. Of course, by persuasive value, we do adopt many into our jurisdiction as well. Okay, let me move on. So far we have covered the aspect of eligibility, novelty, non-obviousness, and general aspects of the utility requirement. Now, where is it that we are going to look at this? Where is all this available? It is available in a document. When you file, there are two ways in which you file. One is called the provisional application. The other is called the filing of complete particulars of the invention, which is a complete specification. So when an examiner is looking at your claim, the examiner is looking at it in relation to the documentation. And what is the documentation? The written part of your specification. So how should the written part be? Should my patent application have 5 pages? Should it have 10 pages? Should it have 10 diagrams? Should it have one figure? Where is the threshold? And that is what is described under what we call disclosure norms, which is also a mandate under the patent law. In the case of the Indian Patent Act, it is under section 10 requirements. So patentability criteria will be looked at in light of the disclosure. So claims of a patent will be read in light of the disclosure. So the intrinsic evidence for the claims is actually the disclosure of the specification is the part of where you read this. So there are 3 norms generally so far as written description, enablement, and best mode are concerned. What are these? Simply put, written description talks about actually description of the invention. So again, depending on the area. So for instance, all of us write a publication, right? A journal publication. The journal society prescribes to you that this is the way in which your paper should have the headings and these are the contents. That is a general guideline. Similarly, if you look at the patent guidelines available for under the each areas, so there are prescribed rules. That, for instance, you talk about a mechanical invention at the state of the application filing itself, one drawing is a must. Okay, right? So we need to understand these aspects. So far as the threshold is concerned for written description, it should be adequate as per the area. That is, if a mechanical engineer is going to read your invention, it should be looking that, well, adequate details are given. I'm not going into the specific tenets of law because that will take us much more time to complete this. I'm moving into the next aspect, which is called enablement. What is enablement? That is, the invention is enabled. So you may write into, let us say, 20 pages the entire details of the invention, but you have not told me how to make and how to use the invention. If you don't tell me how to make and how to use the invention, you have actually not disclosed particularly. So specifically and particularly, you have to disclose by telling me how to make and how to use the invention, because you are getting a monopoly of 20 years in exchange of revealing the details of the invention, right? So enablement comes with what we call the method of operation, the method of making of the invention. Now, one of the method of making the invention will be called the best mode. That is the best working of the invention. And that is nothing but the best mode. So that is in brief, the disclosure norms. So typically, if you look at a patent document, you will find the enablement part in the detailed description of the invention, even the best mode. They would typically say preferred working way. That means that is where your best mode is residing. Okay, so let's move to the next aspect. So this is just the part of the provision that I've put, where it clearly spells out the requirements of what we call contents of a complete specification. So a contents of a complete specification must have a claim, must also have a description, and such a description should meet these requirements, which in brief I explained to you in the previous slide. Again, so far as biotechnology applications are concerned, if you have used any particular material, biological material, the requirements of disclosing the details of that particular material is also a mandate, because post signing up of the Budapest Treaty and implementing that under our law, the source and the geographical origin of the biological material must be disclosed. And wherever the deposit has been made, that reference number has to be put in the in the particular specification. So that is what is the sum and substance. So this is in brief, I would say, the aspect of patent eligibility, novelty, non-obviousness, general utility, so far as the area is concerned, and the disclosure norms. So these are what we call the patenting aspects that we need to know, the substantive aspect of it. Then we move into, once we are clear on this particular aspect, we move into the aspect of looking at the procedural aspects of patents. Yes, we have a document, we have either a provisional specification ready or a complete specification ready. There are additional things that we need to keep in mind because it must be in compliance with the procedure that has been outlined under the Patent Act. So at this juncture, I want us to be reminded of why is it that we need a patent right, and what is the usefulness of a particular patent right. A patent right is a negative right. What is it? It is an exclusive right, and it is not a right for you to use. It is a right for you to prevent others to use, to make the invention, to offer for sale, import, distribute. So you're barring others to use the invention. If you need to use the invention, you need to go and get clearance from the regulatory unit, specific regulatory unit, whichever is the AG of it. So it's an exclusive right. It's a right to prevent others for using the invention without your authorization. So let me move into the aspect of the procedure for patent filing. Okay, I also want to make it a little bit, easier for all of you because the procedure itself is a really large area. It may go into several hours for us to, if we need to go into every single detail, but general thumb rules we need to know. So remember we talked about the prototype. So once, let us say your prototype is ready, but then some of the enablement part, remember we discussed, that is, you have not worked out the total experimental details. Then what are the choices you have? You can go with what we call the provisional document. And that is the stage where you go for a provisional patent filing, where you have the title, you write a small abstract, and you give the description of the invention in very brief and some keywords. With that, you go and file for a provisional application. So obviously, I didn't mention to you claims, right? That means there are no claims in the provisional application. So quickly, you can take what you call the priority date. That is, it's like you're ahead in the queue. Now, once the date stamping happens, then the prior art that will be considered for your provisional will be before that filing date. Okay, so quickly you can go and get the provisional filing date. And then you have what we call 12 months time. Before the expiry of 12 months from the date of filing of the provisional, you must complete filing the total details of your invention. So that means there's a second filing opportunity available for you, which is called the complete specification file. So you had filed a provisional, you told the patent office that, look, I am now proceeding with a process with the patent office with a provisional filing. Now, and you have reserved the priority date. 12 months time, you can complete the details of the experimentation, be ready with your examples, finalize figures, all of that, pack it into a document, get the claims written, because claims represent the property in your patent, and then you go for a complete specific file. So it is at this stage I want to bring you in an aspect called what is it that makes a patent very complex, unlike other disclosures in other aspects of the intellectual property forms, is that a patent document is a techno-legal document. Claims define the boundary of your invention, that is the boundary of your property in relation to a particular patent. But remember that it is half matters of fact and half matters of law. So the law is what you're applying on the matters of fact. So understanding a techno-legal document obviously requires some level of expertise. And so if you see a lot of patent attorneys are available with whom you can actually interact and understand the nuances of where to carve the boundary of your property. And how are you carving the boundary of your property? Prior art, again, that is, your invention should not infringe on an existing patent right. That's number one. Your invention should not read on the prior art. In case what happens? No longer you're presenting novel claims to the patent office. So that is where your concept of novelty application is what you can realize. So you can draw claims to a particular invention, which can be product claims, which can be process claims, system claims, all of that. So what happens after you, let us say you have met the date for the complete specification filing. Now 12 months is that stage you have completed. Now 18-month stage is the stage where your application will be published. That means from the date of filing, 18 months is the timeline for the spontaneous publication from the patent office. Okay. Now how does publication help? Publication helps to publish the details of the invention. That so and so person has taken it forward with the patent office. Now the invention details are available for the public. This provides you what you call provisional rights. For instance, let us say I want to go and file for an invention on that. You are already available, right? As a publication, your invention details are available. In which case, I cannot actually go forward with an invention, though I may have done the same thing. So publication is useful. Now, there's another process of the procedure available where you don't need to wait for the 18 months timeline. Suppose you have filed a complete specification, you may file for what we call early publication. Suppose I know that my technology is highly novel. I do not want competitors to get in. What will I do? I will not wait for the 18 months timeline. I will simply file the early publication fees and get my application published. So I become the prior art for the others. So that early publication phase is also very useful. And remember, this publication is also like a journal publication. Okay. Now, once the publication happens, the details of the invention are available for the public to access. Because remember, this is the quid pro quo of the patent system. A private reward vis-a-vis the public disclosure. Of course, here we are not talking about the patent grant. It is too early to be talking about it. But publishing the details vis-a-vis availability of the invention. Okay, once the publication is met, there are requirements for completing the filing for the examination process. So remember, at every stage, you have to invoke it. Early publication has to be invoked by the applicant. Whereas spontaneous publication, the patent office will do. Now, unless you want the application to be examined, the patent office will not examine it. So you have to call for what you say, invoking the examination process. So once you invoke the examination process, you get into the examination route. And that is where, remember, we talked about section 13 requirements. So the examiner will take up, depending on who is next in the queue. The examiner will be examining as per the criteria, which we already discussed. So in the examination also, obviously you can imagine that there's a big queue at the patent office. So if you want to expedite your examination, there is an expediting procedure by filing for the expedited examination. So you move up a few more numbers into the examination room. That is important because you want your invention to be put forward in the order of grant very early. You want to go through the process early. Obviously, this is an important critical stage because once the examination is done, what actually happens? The formal evaluation of the invention as per the requirements of the Patent Act actually happens. And so obviously the examiner comes up with what you call the examiner report. So the first examination report is the first instance for you to understand whether your invention has been novel, is it non-obvious, and is it meeting the requirements spelled out under section 10, which is the norms for disclosure. Now, let us imagine that you may have a response where there is also a patent eligibility issue that has come up. Remember, that is a big detriment because the law tells you if it is a restriction, it is much more difficult for you to argue with the patent office and get through. So generally, two cardinal things that we always keep in mind is eligibility requirements have to be clearly scrutinized before filing and novelty must be there. So these two things you have to ensure. Inventive step is something which is a shade of gray, I would say. So that somehow one can delineate, but novelty is fundamental. Similarly, one needs to look at eligibility as well. So yes, there are several procedures lined up under the examination. Suppose you get a novelty rejection or let us say eligibility rejection, typically you go for a hearing because what happens is examiner is looking at the black and white document that you're submitting. The examiner may not be able to perceive, based on the analysis, the critical aspects of why you are claiming an invention to be novel. So at the hearing stage, it becomes important to make the examiner know by, let us say, your test methods or your details of the invention, so that you may be able to clear that. Of course, then there is a further process of another examination report that may come. So ultimately, what happens? The claims may be either accepted or may be rejected. Part of them may be accepted, part of them may be rejected. And if part of them are accepted and part of them are rejected, you may have several options again available, obviously. You either amend the application, you do not go for the grant process at all, where in which case, if you're not meeting the requirements of responding back to the FER, your application gets abandoned. So once all of this is done, then what happens? The ascertaining of which claims go forward in the process of grant is completed. And then the publication process of the patent certificate starts. So you must have realized that this is the other elaborate process of the patent filing. So once you get the patent certificate, from the date of filing, you're getting 20 years as the monopoly period. There have been several changes that have been brought as a part of the rule amendments to the Patent Act in order to simplify the administrative process under the Patent Act. The government has brought in a clear lot of changes. Not only that, it has also encouraged women inventors by reduced fee. Also, the medium and small medium industries, that part of it also, there have been significant changes to encourage a lot of people to come forward and file for patents, to encourage that sector as well. So these changes are actually also helping move the process of or rather streamlining and simplifying the process of patenting. Today you see increased number of hearings, which was not the case earlier. So video conferencing mode of hearings is happening. So a lot of simplification has happened. And of course, way back, if you see 2007, that was the early days of online filing opening up. Earlier, it was completely hard copy filing. So today, I would say there's a whole lot of simplification that has happened. Now, this is the national route. That is, you're filing in India, going for a grant in India. Now, your invention may have a lot of value abroad, in which case you can also go for the specific country filing. That is the second option available. If you know that your invention is only has value in US, or let us say in the European Union. Sometimes you have many other territories in which your invention can have a lot of value and clear commercial advantage, in which case another route that is available to you is what is called the PCT route. I'll briefly touch upon that. Now, with the intention that there may be some of you participants who are working with biotechnology inventions, I wanted to put this particular slide, that there's another additional aspect for those inventors who are working with bioresources, in which case you have an additional step of taking a clearance from the National Biodiversity Authority. That is the application of Section 6 of the Biological Diversity Act 2002. What does it simply mean? That no person shall apply for intellectual property rights in India or outside India where an invention is based on a biological resource, because this is the other law where compliance is a requirement. So that is where a no objection has to be sought, and that has to be submitted to the patent office. So what does it mean? There is a coupling of the process. So far as biotechnology inventions is concerned, the Patent Act and the Biological Diversity Act are coupled by the purview of Section 6. So what happens technically, what is the best way out? So you file parallelly the no objection under Section 6. You file with the patent office. Now let us say it is going through the examination process. Okay. By then you get your no objection. You present it to the patent office. Unless you get the no objection, the patent office will not put forward the patent in the order of grant. That means all the examination may be going on, but it will never be put forward unless you get a no objection. So this is something which has obviously given some level of difficulty because of additional process being there. Of course, there are again steps in this on why and how we need to comply. What are the exemptions so far as Section 6 are concerned? Requirements that are necessary for submission, and so far as the NBA is concerned, and that process. I'm not going into the detail. Maybe we can slate it for the discussion part. Okay, so I told you that there is one Indian phase when you're just talking about national filing. The second part is other country filing, where if you're very clear that your invention has value in a specific country, then you're filing there by giving an undertaking to the patent office that yes, you're proceeding with a patent application in a specific territory. Suppose there are multiple territories where you're looking at a value of your invention. There's a process called the PCT application process, which comes under the purview of the Patent Cooperation Treaty. And that is what is called the filing of an international application. So what is it, simply put? That is, let us say I go to the Kolkata Patent Office, I'm filing my application, and I'm telling them, convert this into an international application. Then what happens? It takes a INPCT number. That is, I'm filing in India at the Kolkata Patent Office, and I'm telling them to treat it as though it is filed on the same day in US, in EU, Argentina, China, many other countries. So what does it simplify? That at one place, I'm getting the priority in relation to this invention at other jurisdictions. Okay, I need not go to those individual jurisdictions for the filing. It is also simplifying on one uniform filing fee. So that is one big advantage. Now, most people often undertake the PCT route for the reason that the search reports that come out of the PCT process are also very useful in order for you to get the preliminary assessment of the invention because of the exhaustiveness by which they evaluate the report. So there is a particular process under the PCT where again it goes through definite steps. Now this is only the international application phase, okay? But the international application phase does not guarantee you grant, right? So for the grant is territory specific, so you will need to go to the individual country to get the grant. So you may have a WO application, that is a worldwide application, which is under the PCT, it is the WO numbers published on the website of the PCT. But does it mean it's a grant? It's not a grant. Wherever you want to take that invention, you will now proceed further and enter into what we call the national phase. So what is the advantage of this entire PCT filing? Here you see in this particular slide the timeline that is given to you. So you are essentially gaining on time to take the decision of whether you want to take a particular grant in any particular country. On one end, it is simplifying the filing process for you. You don't need to approach every window of the patent office. The second part is that you are getting a preliminary assessment done. Then you can take the decision of, well, yes, at this stage, I have done the due diligence of my invention and also the commercial route, and you may take a decision of going into the national phase. So up to 30 months is what you're getting as the timeline available for you to enter into the national phase. Again, I'm not going into the specific detail of it, but most times when people enter it into the national phase with their invention, a thorough PCT international search report always helps by getting the preliminary assessment done. So, of course, there is another process of what we call the international preliminary examination done. All of them are non-binding opinions that are available. That doesn't mean that once the international search report is available and you present it to the Indian Patent Office, the examiner of the Indian Patent Office is not bound to be, taking it as it is, okay? Because it is only a non-binding preliminary opinion that you get from the international search report. Okay, so the PCT route is also very helpful in order to, gain the rights in relation to whenever you go into the national phase. So it's again helps a lot of inventors buy time and through that. Of course, there are now several arrangements also by what we call the PCT, PPH, that is the Patent Prosecution Highway route. And, India is also signed up with Japan on PPH route. So what is it happening? This is a good process whereby we can quickly move with the invention in different jurisdictions. If you have one claim examined in one jurisdiction and it is ascertained that one claim at least is novel, with that you can move to the other jurisdictions and present the claims. So this is basically to really bring in what we call, you know, kind of a phase where you have grant in one jurisdiction, but that does not mean you have grants in other jurisdictions. So many times people have to wait for the grants in other jurisdictions to really commercialize their invention there. So what happens is you are able to time it well, that the grant here vis-a-vis the grant in other jurisdictions. So this is, of course, there are many other aspects also of the linkages that are available between patent offices, which are happening through the international route. I'm not going into the details of that particular process. So I want to come to the sum and substance of today's presentation as we have gone through. So the first fundamental aspect of understanding the invention process is important. Then the second phase of looking at what are the requirements prescribed under the law so far as the inventions meeting the requirements under the patent law. We discussed that, the patentability criteria, eligibility aspects, all of it. Now, once that is secured, then we go into what we call the filing, understanding filing procedures, where one can tweak the procedures to the best advantage of the applicant. See, many times inventors are in a rush to the file with the patent office. If you do not have a clear IP policy as an organization, inventors can file later on assign. But if you have an IP policy which clearly mandates organization has the IP ownership, then you will need to look at the organization filing. So there are many of these nuances that are there so far as the application phase itself is concerned. Well, once the patent office examines your application is when you get a clear aspect of whether the patent is approved or it is actually rejected. So all of it is cost intensive, and that is the reason why not only the cost part of it, timing is very important. Remember, intellectual property has economic justifications, which means there is no point in bringing a patent grant when the technology is no longer valid to the market. So you will have to keep the market in mind and plan your patent filing. So patenting is a strategy. Patenting, you are not patenting for the sake of patenting, because it is cost intensive, it is time intensive, and ultimately, when you get the grant, you should be able to use it, right? So therefore, this understanding this is obviously very important. So usually, if one is not very well trained in the aspects of law and the patenting aspects, it is good to hire an attorney who can advise you on the filing part of it as well as the proceeding with the patent office. So I think with this brief deliberation, I would like to close and open it for the discussion. Thank you so much for your patience, and this is my email ID. You may write to us and I will be available all time for clearing any doubts that you have. Now, we have over the year come up with a course on patent search because we believe that the capturing the early process of the invention is very, very critical, because all this procedure, all of it is fine. But if we are really not capturing inventions in the early phase and not knowing whether or not we are working on novel technologies, patenting has no meaning. And with that intention, we came up with the India's only unique course of patent search for engineers and lawyers, which is an NPTEL course. It's currently running in the registration route. So those interested, you may please apply, and we have an online course on that. Thank you so much for your time, and I'll be open for the discussion.
Yeah, thank you, ma'am. Yeah, thank you so much, ma'am, for your great lecture. Just your brief introduction is remaining. Just before going to question and answer session, I want to give a brief introduction to all the participants. We observed that today more than 1,500 participants are listening to you, ma'am. More than 1,000 people are registered. They are enjoying your lectures. So just I will start a brief introduction to the participant. Dr. Padmavati, Professor, Rajiv Gandhi School of Intellectual Property Law at the Kharagpur. So teaching, ma'am is specialized in patents. Ma'am teaches patent law, IP management, patent procedure, and drafting. traditional knowledge protection to undergraduate law students and master students of the law. Her primary area of research includes intellectual property and commercialization of recombinant and herbal drugs and drug regulation, biodiversity law. Ma'am has a more consultancy research projects from MHRD, Government of the India. Ma'am has also awarded with Microsoft Young Faculty Scholarship in Intellectual Property Rights. Ma'am is also advisor to the IPR Cell, IIT Kharagpur. Ma'am also a course coordinator of the Kiran IPR program at IIT Kharagpur for training women scientists in the IPR. Ma'am has guided around 60 master students and 6 doctoral student research in IPR. Ma'am has published articles in more renowned journals of the IPR journals are concerned. Ma'am is also a member of professional bodies such as World Bioenergy Association, International Patent Information User Group, International Trademark Associations, and many more. She is a steering committee member of Kiran IPR programs. Also, ma'am is a panel member of Food Safety Standards Authority of India, Government of India. Ma'am is also a editorial board member of Journal of Intellectual Property Rights, and she is also invited as a speaker at more international as well as national conferences. Very good lecture, ma'am. I just give a very brief introduction about you to all the participants. It's very nice. Now, question is open for the forums. Now, as we are putting some questions from the YouTube also and Zoom, I will ask some important questions from that way.
Sure.
Some participants are asking me about where we can get the invention disclosure process form.
Okay. See, invention disclosure form has to be made by your individual organization. There are some specific categories which can be utilized. I can share an invention disclosure form of IIT Kharagpur, which is a public document that is available. So basically, in the invention disclosure form, you have the details of the inventors, their designations, their names. Then you have the title of the invention. Then there is a description portion on why an inventor or inventors think that the invention is novel, why they think it is not obvious. Then what is the relevant prior art in relation to an invention? Remember, all prior art is a bigger group, right? But there is a prior art which is very close to the invention. That is what is called the relevant prior art. So a listing of those patents or the journal publications and how their relationship is there with the invention, that description is given. And then the figures, the photographs or the tabular data, so far as the invention is concerned. So typically it's like how you write a journal publication. It's like a preprint, how you prepare like an abstract, all of that. Because the preliminary assessment should be done by your organization, whether it is novel or not. Remember, I told you that the patent procedure is a very costly and time-intensive procedure. So unless we know for ourselves that the invention is novel or not, it's not worth going to the patent office. So this invention disclosure form will actually help you. Not only that, every inventor needs to sign. That is, they're committing themselves that they were the inventors in relation to the invention. Because tomorrow someone may come up and say, look, I also worked in the same lab. By working in the same lab, you do not become a joint inventor. You would have had to significantly work on the skill of the invention. You would have had to participate at least in one claim of the patent in terms of the doing of it. Only then you become inventor. So these are all like a kind of an official record that you need to keep. Because one, for the initiation of the patent filing procedure. Second is, there could be issues of inventorship. Also, tomorrow, suppose, let us say the invention is commercialized, okay, you're getting royalty. So how do you distribute royalty? For that also, you need this document. This becomes the important document by the IP cell to determine that, okay, this is the status of contribution. This is how the royalty sharing will be. So in all ways, having an invention disclosure form is very important. So you can develop one for your own institution and let it be as elaborate as possible. There's no harm in that. In fact, at IIT Kharagpur, we have an online portal in which inventors submit their documentation details, in preliminary details. Then once we know that preliminary assessment is done, immediately they file for the completed details of the invention. And that is when whether or not the process starts on the patent filing.
Yes, ma'am. Very nice answer. Thank you, ma'am. Next question, ma'am. Can we file patent of our research work of PhD? If it is yes,
Yes.
then what is the procedure actually for filing?
Okay, so yeah, this is a good question. Yes, so sometimes what happens is there are students who come and say that they are, going to be completed their PhD. They are giving a synopsis presentation, or they have completed the draft thesis. Can they go for early the better? Before your thesis is published in the website of your institute or in the public domain, please go for patent filing. And what do you do? Again, please go back to the discussion what we had. If you have developed a novel product or a novel process, make sure you get it cleared for whether that is patentable or not. Once you know that at least the novelty is there of the invention and it is eligible under the law, at least go for a provisional filing. After that, the next day you go and publish it on the website, whatever will not destroy the novelty. Okay, after the date of filing, novelty destruction doesn't happen. But before the date of filing, if you don't do, then you may lose the invention. Someone may read your PhD thesis and then may proceed with patent filing. They may modify your invention. So you may potentially lose out, right? So we encourage people to file at least a provisional, and then have an online PhD thesis submission, whatever it is, because that is a big threat otherwise, if the details are published beforehand. I hope it's clear.
Yeah, yes, no, it's very nice answer given by you. There is one more question. Is there any difference between patent filing through university or through private organization?
Okay, yeah. See, university filing and private organization, there are subtle differences because, see, in private organizations, the strategies are different. So far as patent, how they approach patenting route. Universities are much more flexible so far as patent filing is concerned. But there is also a greater time universities can afford, whereas an industry cannot afford that kind of time. So far as the procedure is concerned, it is very uniform. It doesn't differ for universities or the private organization. All of us have to be compliant with patent law so far as the procedure is concerned. But the procedure for getting to the process of provisional filing, that entire process, from the invention disclosure to the, the preliminary filing part, that may vary between a private organization and a university. Another thing is the royalty sharing will also change. See, ownership here is with respect to the university. Okay, if the university decides that, look, this is an area of research that we don't want to proceed with, university may just simply allow you to take your own rights, in which case inventor can go and file for yourself. But typically, if you look at private organizations, they would not easily give ownership. Okay, so these things are little different so far as universities and the private organizations are concerned. And of course, both are legal entities so far as that is concerned. Sometimes I have at least known of institutions in India who have encouraged inventors to file first because the filing fee will be less if you're an individual inventor. Later on, you can assign to the institute. So it depends, universities have sometimes very flexible policies, and some other institutions have a clear-cut IP policy which tells you how to manage your IP, how to go for the filing of IP. Royalty sharing definitely will be very different so far as private organizations and universities are concerned. Even within universities also, royalty sharing differs. Some people give 20% of it to the inventor, 80% to the inventor, 20% to the organization. Some institutions I know of in India who have 40% to the organization, 60% to the inventor. So it is little different that way. But the procedure of filing is uniform as per the law, whether you are a organization, whether you are a private entity, whatever. Except, of course, if you are an MSME and things like that, yeah, filing fee is reduced. Those things are obviously. Yes, I hope it was okay. You're able to. Yeah, go ahead. Yeah. Any other queries?
Yes, ma'am. There is one question from Tejaswini Jagdale. She has asked that what is your opinion about patent laws after 5 years? As we all know that frauds related to the IPR are increasing day by day.
Yes, ma'am. You are
Yes,
very nice.
that is true. Yeah. Next 5 years, what will happen? It's. I think there will be.
There is any patent procedure in, let's say.
Sorry, can you repeat that? Whether there is any patent procedure? Can you repeat that later part?
Ma'am, the question is, what is your opinion about the patent law after 5 years? Because the frauds relating to the IPR are increasing day by day.
Right. Yeah. So I would see, as you see, different patent offices are bringing in a lot of administrative changes with individual patent offices within and even across. So a lot of arrangements are happening between different patent offices in terms of international cooperation. The trilateral examination practice was the earliest that we knew. Post that, you have the IP5 grouping, where many Asian countries are also sharing what you call examination practices. So if you remember in the lecture I talked about that every inventor wants an early grant because IP is economic in nature. So suppose 20 years is my monopoly from date of filing and I already 10 years are lost in the entire grant process only. I have only 10 years to exploit my invention. So this actually is a detriment for the inventors to go for filing with patent offices or even entities to go for filing. So obviously people are looking at streamlining procedures. Is it possible for, let us say, our patent office to share examination practice with another patent office? Then what happens is we accept that this examination practice will be shared. So this will bring in a lot of what you call, streamlining in the procedures under the patent law. So that is something which is, I can see that greater and greater that will happen. Not only that, if you see in the COVID times, this is a very interesting development that has happened, that patent officers have now brought in much more changes because of the COVID scenario. They have brought in much more simplicity in terms of hearing, in terms of filing, and adjustments of timings. Because then again, as per law, statutory timelines are being adjusted. So those things are actually a very important, valuable thing, because otherwise inventions in this space of the lockdown, we will be losing them. So that is where you see it's really very remarkable. Patent offices differently, worldwide are reacting to this thing. The other thing that I can see patent law going forward, I feel that some stage we are going into what we call from the generality to speciality. That is, patent laws have become so domain specific. If you're looking for patenting in the software area, it's like almost a completely new discipline under patent law. Biotechnology patenting is almost like, you need a thorough set of different provisions that you need to link up. So my feeling is that maybe we will be going into more and more of specificity and more of complexity. See, if you're looking at some of the areas of nanotechnology, the areas of robotics, or current, areas of artificial intelligence used in the area of patents. So it's getting much more complex. So you need, I would believe, the critical part of a patent office is the examination division. And I think there I would believe there should be remarkable changes. There should be remarkable changes where, examiners, already you have procedures where examiners can, inventors can talk to examiners. These things are there. So I would believe that we are going to get more and more into domain-specific IP, because patents are like that. Patents are techno-legal things. So there are equal credence of matters of fact and matters of law. And if you do not know technology, because technology is becoming so complex, the application of law is very intricate. In fact, when we study interpretation of statutes, this is one law where a lot of interpretation has come out. Case law has really brought in a lot of interpretation of the black letters of the law here. So my belief is that it's going to get more and more complex. That's my straight answer that I can tell you. And it's going to go more and more into domain specificity. So we need a lot of elaboration of these units under the patent office. Because see, if I have to have faith in the patent system, and let us say I'm a biotechnologist, and if I file for an application in the biotechnology area, I would like my application to be looked by a person from the area. So that is where I would believe that more and more specificity is being brought in. So that is something which is good to see. And the auditing part of IP offices also, I think, uh, is also going to be very important, because again, this is not very core to our discussion today, but there's something called an alternate IP situation that is coming up, because discouraged by this aspect that patent rights are taking, procedures are so long drawn. So people are now opening up into other areas of, uh, other than patent scenario. So if the patent system has to really bring back inventors into, going into the patent grant phase, we need a lot of simplification of processes, and auditing is important. So if you see, many patent offices are now reimbursing you examination fee, reduced, at least 50% of your reimbursement of examination fee. These are good things to be, because ultimately, see, if you are going for an average modern, modest, this thing takes you at least 1 lakh. And time, money and time are two things. So therefore, I think IP auditing uh, is something that will be the next stage, and every patent office will try to attract inventors to its thing. And of course, you see, I think we need to have also pooling of IP. In a scenario like COVID, as you rightly see, the WIPO has brought in the patent pool. So where you really need to suspend patent rights. So greater amount of patent offices, outreach. So patent office also has a public purpose, right? It is not just the administrative system under the Patent Act. So the public purpose of patent offices, I think I'm beginning to see a lot of it. And I think that's the way forward. I hope I've answered your question.
Thank you, ma'am. Now the next question is from TLMV Subbarao. That is, Indian patent may not be applicable in US. Then how do you make your patent to be applicable everywhere?
Okay. See, often we come across scenarios where inventors come to us and they tell us that, look, in India, we do not have commercial value. My invention has value in the US or maybe in Israel, any of that. In which case, we do an assessment and then we go into that specific route of filing. So we only simply go for the US filing. So you have to do that assessment. Unless you do the assessment, it's not going to be worthwhile, exploring to go for grants. There is nothing called a worldwide grant. There is nothing called a worldwide grant of a patent. Okay, there is only territorial grant. That means if you want the grant to be, let us say, in UK, you want the grant to be in US, you have to actually now initiate it with those individual countries. You have a PCT route, at least the filing process is becoming easier. But then the later part of it, you will need to take a call on whether or not you want to go for the individual country grant. And that is where the commercial value of an invention will become important. Because unless you are clear about that, going for US filing or EP filing or specific country filing has no meaning. Because remember, there are costs involved. And the procedures at their patent offices are also different. Because at the USPTO, if you're filing, you all have to pay not only the filing fee, there are documentation submission is different compared to the Indian Patent Office. You have to file for disclosure documents of prior art. Here we don't have that. You have to file IDS 1, IDS 2. Then there are further procedures. So it means a whole lot of things. So you have to take a very, I would say, a determined approach. Unless you're sure, just for the sake of filing doesn't make sense. That is where, again, universities and private entities differ. Because I told you, private entities are very strategic. They do all their planning right at the stage of the invention disclosure. They don't wait. So such kind of a thing in universities is not that much, because we are not driven by IP, right? Whereas if you look at industry is typically driven by IP. We are driven by research, and then IP comes in later on. Whereas industry is driven specifically only by strategic need to secure IP first. So that is so one has to do that assessment, that whether it has value for you in that jurisdiction or not. Because everywhere you have to pay costs, right? So that you have to keep in mind. Yes, I hope that was clear.
Thank you. Yeah, thank you, ma'am. So it's very nice. We are putting some more questions. It's over now.
Okay.
So
You
I'm
may
very much
send those
thankful.
questions to me, so that if you can put them into an Excel sheet kind of thing, and if you send it to me, I can answer that. I know there is time is short. I can appreciate.
Yes, ma'am. We definitely do this. Now we move towards our last session. I'm very much thankful to you, ma'am. You are covering the whole process of the Patent Act 1970, as is amended in 2005 also. You are discussing about the invention disclosure process, inventive steps, definition mentioned in section 2, clause 1J, invention, inventive steps, definition of inventions, then actual concept and meaning of the patent, prior art, then anticipation, then novelty determinations, then what are the rights of the patentee. Then he also talks about the PCT, that is patent cooperation treaty is concerned. So you are touching every issue, including your provisional and complete specifications of filing a patent also. It's very nice lecture. It's very fruitful and beneficial to all the research scholars, to all this field of the communities, particularly science fields, because the students are required to file a patent. Maybe they in dissertations, they do some work, and they are always pointing out that, sir, whether how patent can be filed. So I think that Dr. Padmavati ma'am is a very great resource person, because I am a student of her, and before patent search for engineers and lawyers are concerned, I'm a student. So I think she's a better resource person, and she's nicely, ma'am, you are giving very nicely enlightenment, highlightment on all the patent process is concerned, and comments which are showing on my the laptops are clearly showing you are very excellent session, very nice session, clarify every doubts are concerning. So I very thanks to you, ma'am, from my directors from Government Institute of Forensic Science, and I'm in touch with you also in the future course of actions also. So it's very thank you, because in a very short span of time you can accept our invitations and give a very nice talk, very deliver, and a very expressive talks on the patents. And very thank you, ma'am, for bottom of my hand. Thank you from the institutions, and particularly from my side as a student of you. You are really giving so much dedications to the students' invitations, and immediately accept invitations and deliver a very nice talk. I'm very thankful to you, ma'am. Yes.
Thank you. Thank you so much. Thank you.
No, I declare
Thank you for
session
the
is
kind
over.
words.
Yes. Yes, ma'am. Thank you so much. Yeah.